Woman charged in connection with shooting death of 14-year-old girl. A 25-year-old woman has been charged with accessory before the fact and accessory after the fact to murder following the killing of a 14-year-old girl in April. The woman has been identified as Daniela Morrison, a contractor of Walton Park Road. She is charged in connection with the brutal murder of Terona Thomas, otherwise called TT, a student of Cinnamon Crescent in Kingston 11 on Thursday, April 17. Reports from the Olympic Gardens police are that Morrison and the man rented a silver Nissan Note motor vehicle, allegedly, to carry out the fatal attack. That afternoon, about 1:50 p.m., and our man allegedly traveled to Hill Avenue in Kingston 11, where he opened fire on a group of people, hitting Thomas and two others before escaping. The police were summoned and the injured persons were assisted to hospital, where Thomas was pronounced dead. The other men were admitted for treatment. Following the incident, Morrison allegedly retrieved the car from the man and returned it. She was later formally charged following a case review. Prime Minister Andrew Holness has offered a $2 million reward for information leading to the arrest and charge of Tyrone's killer. The St. Andrew South Division says it is pursuing other suspects connected to the incident and is again appealing to anyone with information that can assist in investigating this or any other crime committed within the St. Andrew South Police Division to contact the Hunts Bay Police, CIB, at 876-923-7111. St. Thomas Parish Council worker dies after hit and run. The St. Thomas police are investigating a hit and run that claimed the life of a woman in license in the parish on Friday night. The deceased has been identified as 60-year-old Sharon Hastings, of a licensed address and an employee of the St. Thomas Municipal Corporation. Reporters understand that sometime after 6 p.m., Hastings was crossing a roadway when she was struck by a vehicle. The driver failed to stop after the crash. Hastings was rushed to a medical facility where she was pronounced dead. 316 road deaths recorded since January 1. NRSC urges caution on the road this Heroes Weekend. With 316 road deaths recorded since the start of the year, persons are being urged to exercise caution when using the roadways, especially over the long Heroes holiday weekend. Vice Chairman of the National Road Safety Council, Dr. Jones, made the appeal following the deaths of two men along the North-South Highway. Dead are 31-year-old Maria Walker of Phoenix Park Village in St. Catherine and 56-year-old Ryan Grant of Seaview Gardens, Kingston 11. The crash occurred in the vicinity of Angels Spanish Town, St. Catherine. Reports from the Ferry Police are that about 8:15 p.m., Grant was driving a white Subaru Legacy motor vehicle in a southerly direction when the car collided with a gray Subaru Impreza, which was being driven by Walker in the opposite direction. Upon impact, both vehicles caught fire. Walker and Grant sustained multiple injuries and were taken to hospital where they were pronounced dead. Expressing sadness at the tragedy, Dr. Jones said road users must be vigilant. He renewed the appeal for all stakeholders to work together to reduce road crashes.
Two precious lives were lost last night. We need to be very vigilant on the roads to make sure we don't lose any more lives, that everybody will reach home safe this weekend. It's been a rainy week. The roads are wet. People need to slow down and live. Slow down. Be very careful on the roads. How you walk, how you drive, how you ride. We don't need to have anybody die Saturday, Sunday, and Monday. But that will only happen if people, when they go on the roads, the drivers and the pedestrians and the motorcycles, are extremely careful during this weekend. And let's not stop this weekend. Let's continue to be vigilant. Far too many Jamaicans are dying. Far too many Jamaicans are suffering terrible injuries. And it is making a huge problem for the nation, for communities, for the healthcare sector, and ultimately for families who lose loved ones. We have so many other problems. This one is highly preventable. We can put a stop to this. Both state, civil society, church, and road safety advocates need to be in one accord about this ongoing, highly preventable national problem. Let's all try and reach home safe this weekend and during the rest of the year.
$5 million for 154 days behind bars in 2019 state of public emergency. a Hanover man who was seeking just over $68.1 million in damages from the state for breaching his rights after being detained without charge for 154 days under the April 2019 state of public emergency declared for the parishes of St. James, Hanover, and Westmoreland, has been awarded $5 million in total by the Supreme Court. According to court records, the self-employed man who worked as a security guard, shop owner, fisherman, and taxi driver was arrested and held for processes under the SOE at Hanover Police Station, Lucy, in 2019, in the first of two instances. According to the man, he was told at the time that he would be detained for 90 days. However, he was held for 154 days. The man, through his attorney John Clark, said he received no copies of any document, the particulars he signed, nor official notification of the private data taken from him. Further, he claimed that he did not consent to the collection of this data or its private information. He said on advice of his lawyer, he applied for his release to the tribunal constituted to hear such matter and was subsequently released after 154 days in custody. The tribunal, upon hearing his petition, had ruled that the evidence presented on behalf of the first defendant, the Ministry of National Security, was insufficient to prove, on a balance of probabilities, that the claimant was involved in acts detrimental to the public safety or public order, and ruled that his detention be revoked and discontinued. The man who requested that all his private information and relevant data be deleted from the government database said he was also not advised of his rights to petition the tribunal. A police detective sergeant who gave evidence during the matter in explaining the decision to arrest the claimant said, based on all the information collected on him, a reasonable and probable suspicion was formed that he was a member of the 101st Gang and the leader of the Cash-in-Hand family armed of gang, which was involved in lottery scamming and extortion. Clarkin arguing that his client was to be awarded just over $68 million and that awarding of that lesser sum would not emphasize the importance of the affected rights in light of the new approach demanded by the Charter of Rights, said he had been deprived of his liberty and was neither treated humanely nor with respect from the inherent dignity of a person. According to the claimant, there are about 17 other prisoners in his cell. Special permission was required for bathroom use, and he was not locked down for the time he was detained until his release. Furthermore, he said the cell had no running water or bathroom facility, and any exist required permission. He also said that many times he had to use a bottle to relieve himself. He said that after 90 days in that first cell, he was moved to the back cell, which housed more than 8 inmates. The man who said while he was treated inhumanely and degradingly, complained that he suffered anguish, pain, and embarrassment among his family, members of the community, and public, and has incurred expenses securing his release from detention. He further said he lost his income and money he would have earned during that period and sustained loss and damage as a result. During the matter, which was heard in the Civic Division of the courthouse before Justice Sonia Wint Blair over 3 days between December 2024 and September this year, the man sought his court's declaration on several issues, including whether Regulation 30 of the Emergency Powers Regulation 2019 breached his right to liberty, protection from search, privacy, and whether he was entitled to vindicatory, aggravated, and exemplary damages and entitlement to damages for false imprisonment. His attorney further argued that his client had incurred transportation-related expenses while incarcerated and submitted that the state should cover his legal fees, loss of income, and transportation expenses. Attorneys of the state, however, contended that Clark's client had not provided any proof that he was earning from his jobs. The court, in noting this, pointed out that while the man had claimed that he incurred legal fees to submit his objection to the review tribunal, no receipts were exhibited as evidence of payment. Also, the claimant states that he incurred transportation expenses in the sum of $120,000. It is, however, unclear how the claimant incurred transportation expenses while in custody and whatever for, the court noted. The court pointed out that, in effect, the claimant has merely pleaded these special damages without providing any evidence to substantiate them, and said it accepted the submission of the state's attorney on damages. As such, it said the award will be made in accordance with their submission, with damages limited to 30 days for the tort of false imprisonment and vindictive damages to redress the constitutional breaches of the right to liberty. The court ruled that Regulations 22 and 30 for the Emergency Powers Regulation 2019 are in breach for the 2011 Chartered Rights, and that the claimant's right to liberty was breached as he was not released as ordered by the Emergency Powers Review Tribunal. To subscribe, like, share, and click the notification bell for daily updates.